What if I'm using my trademark, but I can't prove it? Somebody asked me this question. I'm going to answer it live here today. I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to answer your trademark and copyright questions. If you have those, drop them into the comments below that video. I will answer them on a future live. So somebody asked me, what if I'm using a trademark, and I need to file an application, but I can't prove my use for some reason? Well, this happens more often than you would expect. Now, just as a refresher, remember that there are two ways to file a trademark. You can either file based on your actual use, or you can file based on your intended use. If you want to file based on your actual use, then at the time of filing, you must submit what is called a specimen. And I know that sounds like the little jar that you leave in the cabinet at the doctor's office, but in trademark land, it's something entirely different. In trademark land, a specimen is proof that you're actually using the mark as a trademark, and you must submit that with any application in which you allege that you're using currently the trademark. What if you can't do that? There might be a number of reasons why you might not be able to do that. For example, maybe your website got hacked, and so now the page that you would have screenshotted to prove your use is gone. But you need to file that trademark application. So what do? Well, there is an option. You can file based on your intent to use the trademark. But Angela, I'm already using the trademark. Why would I file based on my intent to use? Well, you would do that because you want to preserve your trademark rights. When you file a trademark application, you get a priority date, and that priority date is the date that you filed the trademark application. If you don't file the trademark application, there is the possibility, however small or big, we don't know, that somebody may, during the time that you are waiting to file your trademark application because you need that specimen, there may be somebody else who might come along and file a trademark application for your similar mark for your goods or related goods. And then, sorry, but you're out of luck. You're not going to be able to get a registration if there is an application on file that eventually goes through that conflicts with your own. You missed the boat. So how do we avoid missing the boat? If we are using the trademark but can't prove it, we file based on an intent to use. Now, that does not mean that you're not actually using it. It just means that you can't prove it. So we file based on an intent to use, and then later, when we can produce the specimen, we file what's called an amendment to allege use or a statement of use, depending on what procedurally has happened in the trademark application process. So don't worry if you don't have a specimen or proof of use right now. You can always file based on your intent to use the mark in commerce and then produce that specimen later. But filing the intent to use trademark application preserves your place in line, it preserves your priority date, and makes sure that nobody else can sneak in front of you and file a competing trademark application. I'm Angela Langlotz. You can find me online at TrademarkDoctor.net. I'm also on YouTube at video.TrademarkDoctor.net/YouTube. You can ask me any questions below in the comments. I will answer them on a future live. And don't forget to like and subscribe so you get all my newest content.